People versus Martinez-Fernandez.
May it please the court, Sylvia Lara Altruder of the Legal Aid Society. On behalf of Edward Martinez-Fernandez, I would like to request 3 minutes for rebuttal.
Yep.
Nice to see you again.
It's been a long time. I'm going to address the difference in Mr. Martinez-Fernandez's case with respect to the 511 charge. The only difference in the factual allegations underlying his complaint versus Mr. Willis' complaint is the allegation that he was unable to produce a valid license. As was talked about yesterday before this panel.
And what impact does that have on this case versus the other one?
None. The complaint charging Mr. Martinez-Fernandez is still facially insufficient. Not being able to produce a valid license does not mean, as was argued yesterday, that he knew or should have known his license was suspended. Not having a physical copy of your license has very little to do with knowing your suspension. When your license is suspended, you don't turn it in. And the fact that he, at some point, from his trip, from the traffic accident that he was involved in to when he was arrested.
Did you say when your license is suspended, you don't turn it in?
That's correct.
Aren't there instances where you have to surrender your license?
I believe in certain cases there are, but that's not alleged here. And not in all cases. But yes, not in all cases. But there's also no connection. Mr. Martinez-Fernandez was arrested at the hospital. There's no reason that not being able to produce a valid license at some point between the accident and when he was arrested at the hospital means that he knew that his license was suspended.
I mean, maybe solitarily that's true, but I think in conjunction with everything else that's in the complaint, why isn't that a reasonable inference to say that, and by the way, he didn't produce a license, which the reasonable inference is he didn't have one or it was suspended, and then everything else that you just mentioned becomes a defense?
It would be, I think it would be presumptive evidence that his license, that he didn't have a valid license, which would support the traffic infraction, the VTL 509. It does not support the aggravated unlicensed driving of the VTL 511. And for all the reasons I talked about, the form allegations, these boilerplate allegations about the summons and the language that's allegedly on the summons and that your license is suspended 4 weeks later by computer are insufficient to show that he knew or he should have known his license was suspended. I'll then turn to the reckless driving charge. So Mr. Martinez-Fernandez's case, the charge of reckless driving does not help this complaint survive. There are no non-conclusory allegations in the complaint that Mr. Martinez-Fernandez was doing anything unsafe, that he violated the rules of the road, that he was speeding, that he had been drinking, or was in any way at fault in the traffic accident that followed.
Well, he crossed a double yellow line and a motorcycle hit him.
Yes. And crossing a double yellow line is not per se illegal.
No, but you do have to give way to traffic that has the right of way.
And there's
on the
no
other side of the double yellow line, right?
I'm sorry, could you repeat the
Yeah,
question?
sure. I mean, you cross the double yellow line, the other traffic is coming the other way from the way you were going, right? That's necessarily true.
Yes.
And you have, if you're crossing, you have to cross with extreme care and make sure there's nothing coming at you.
Yes.
And a motorcycle crashed into him.
Yes. But that there's no evidence in the complaint that Mr. Martinez-Fernandez was at fault for that accident. What he says, and what's alleged in the complaint, is that the motorcycle was speeding when it hit him. The officer that swears at the complaint, she alleged that he caused the motorcycle to hit him. Causation is a legal conclusion, and there's no basis for the idea that Mr. Martinez-Fernandez was at fault for the accident. There's no allegation, for example, that he wasn't acting with care. What he says is that he was trying to park, which for many people, they take tremendous care when they're trying to park on the side of the street. And so for that reason, the entire instrument is facially insufficient. And so we would also ask that the remaining VTL 509 charge, the traffic infraction that remains, be dismissed. There is no peniological purpose in proceeding on that remaining charge, and the prosecution does not contest that. If there are no other questions, I will see my time.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Elliot Robert Hamilton for the people of the State of New York. The factual allegations in the misdemeanor complaint and the reasonable inferences to be drawn therefrom supported each element of the charge, and in particular provided reasonable cause to believe that defendant operated his vehicle while he knew or had reason to know that his license was suspended. And there were several facts that supported this conclusion based on the totality of the circumstances. He failed to answer 5 separate traffic summonses. And by DMV regulation that was cited in pages 20 and 21 of the People's Brief, that those traffic summonses must be handed to the motorist. And by being handed to the motorist with the language that was mentioned in the complaint, it put the defendant on actual notice that failure to answer within 15 days would result in his license being suspended. That inference and that language was more than sufficient to provide the defendant an opportunity to prepare a defense and to prevent double jeopardy.
Which ones had to be handed to him by law?
Anything involving a moving traffic violation.
So for example, the, where is it, failure to stop for a school bus?
That would be, my understanding is that would be
There's school
handed
buses
to-
that have cameras attached to them, and there's camera tickets sent to people?
I don't know, I believe that there are cameras, and I don't know the specificity of how that would work, but with respect to any time that an officer observes a traffic infraction and pulls over a motorist in violation of the VTL, they must hand over those summonses.
Great, but I guess what I'm asking is, I'm not sure which one of these you're identifying as ones that must have been handed over. For example, disobeyed a traffic device sounds to me perhaps like running a red light, and there are red light cameras. Improper turn, you can't make a right turn on red in the city, that could be a camera violation. I don't know if they're issued for that, but is there something authoritative you can point us to that would map to any of these that would conclusively demonstrate it had to be handed to a person?
I would say that in our brief, we ended up cited to specific moving violations as being required to be those summonses be handed to the motorist.
With respect to the school buses, for instance, there are private entities. They take a picture of your car and they send people tickets, sometimes months later.
That's possible, Your Honor.
So how can we be sure this is, as the chief said, that this is the type that mandated that he be given it?
I think you can, that would be an issue. I would submit that would be more of an issue at trial, where when looking at the actual summonses, where they were as part of when the DMV provides the notice of like if a DMV representative providing the notice of the suspension.
So at least for sufficiency purposes, it's okay. It may
right.
not ultimately prevail at trial, but for pleading purposes.
That's correct, Your Honor. And because the defendant waived prosecution by information, you only need to view it under the reasonable cause standard.
If we knew that the summons were all just delivered by mail, would that be sufficient? You're hypothesizing that at least some of them, I think, would have been handed to them, but it also sounds to me like we can't be 100% certain that that was the case, based on what we have in front of us.
I would say that's accurate. There are many ways, as my adversary pointed out, there are many ways
Right.
that a license
So
could be suspended.
let's assume that we had a case where we knew that all of the summons were mailed. None of them were delivered by hand.
Mm-hmm.
Would that be sufficient on a complaint, and why?
It would be sufficient to know would be sufficient, and it would be sufficient. And I would furthermore state that where the DMV abstracts, which was appended to the complaint, stated that he failed to answer those summonses, you can reasonably infer that when the DMV has specific protocols for upholding like upholding the VTL, and they have the authority to suspend someone's license by failing to answer that you could, that the fair inference that could be made for purposes of reasonable cause, that the basis for the suspension in this case was that he did actually receive a summons
Counsel,
directly.
I'm sorry, having been mailed a number of nice photos of my car when family members were driving, I was under the impression that those tickets are to the automobile. So if something appears on your own violation sheet as you violated the statute, that's not a mailed ticket, because you don't know who's driving,
Yeah.
right? It's just a registration ticket.
That was actually going to be, just as an append to that, that was going to be my question to your adversary when I was asking about failure to wear a seatbelt being issued from a camera violation. I mean, unless you're using CIA facial recognition software, how do you know who's not wearing a seatbelt?
It's just a fine.
On a camera violation.
No, and your honors are correct about that, and there are many different summonses and moving violations that would append to the registration. That failure to answer those tickets will result in the registration of the motor vehicle being suspended, and it's the same with parking tickets, which are completely separate and apart from, because those are done, the agency that handles those is the local police force. But with moving violations in particular, the reasonable inference is that the DMV regulates that, they uphold these rules, and that the officer who is assumed to uphold those laws and pull over people is familiar with the paperwork that they end up handing over to a motorist that has that warning in there. And to your honor's question about the unable to produce a valid license, while it's true that it's not presumptive evidence that he knew his license was suspended, but it probably is presumptive evidence that he knew that his license was no longer valid, and we submit and that all of the inferences made in the complaint illustrate that defendant had, at the minimum, had reason to know that his license was suspended based on the reasonable cause standard. And if your honor, and regarding the training and experience point, every time that this court has held that training and experience was necessary is where the deponent officer required that special expertise to allege critical facts to distinguish illegal conduct from legal conduct, that an officer needs to specify that excessive tints had to be below the 70% threshold as opposed to the legal limit, that a defendant is holding a gravity knife as opposed to a pocket knife. And those facts are specifically important in those circumstances because the defendant, when an action is commenced, you don't want a defendant to be prosecuted wrongfully for legal conduct. Here, the officer is merely speaking about information that is set by law and regulation, and there is no special expertise that an officer utilizes when averring to these facts that are set out by the DMV. With respect to point 2, I would submit that the officer's observations of the video surveillance based on under penalty of perjury established reasonable cause to believe that he was driving recklessly. When that, in addition to the officer's averments pointing out where the officer saw the defendant's car in relation to the road, shows the inference that not only when he tried crossing the double yellow lines, he was moving from the southbound lane to the northbound lane, and the car appears to be perpendicular to the double yellow lines, which directly resulted in the blocking of the lane of traffic, which resulted in the motorcycle.
But that wasn't in the complaint, that description that you just gave, right?
Well, on the first page, Your Honor, I would say that the vehicle was sideways in the street, blocking the northbound lane of traffic. But that
alone's not necessarily indicative of reckless driving, is it?
It's indicative that at the time of the accident that he blocked the free lane of traffic, which but for the defendant's actions would have allowed the
That
motorcyclist
was
to continue.
based on a videotape, correct?
So it was based on
The
the.
videotape wasn't attached to the complaint, but would have been handed over to convert it to an information.
The video is not required for purposes of conversion, but the defense but it allows the defendant to prepare a defense as to what he ended up saying, and the officer swearing to the contents of what she saw in the video, and if upon receiving the video and discovery that the defendant has the ability to watch the video, and if it so happened that the officer was not telling the truth, then it could be the basis of a motion to dismiss. And even if your honors do believe that the 511 charge was facially insufficient, because the reckless driving charge was facially sufficient, this court's holdings in People v. Keyser and People v. Thiam allow for a defendant to plead guilty to an insufficient charge as long as an equal grade misdemeanor charge was sufficiently pled. And we submit that that was the case here. If the court has no further questions regarding either of the 2 points, we ask that you affirm the appellate terms order.
Thank you.
To respond briefly, the confusion I think that's identified about how these particular summonses are distributed, whether certain ones by mail actually attach to the registration as opposed to a person, whether there are private entities that mail these summonses months later, explain why, for this complaint to be facially sufficient, the officer needed to allege how these particular summonses were distributed for the purpose to establish that Mr. Martinez-Fernandez knew or should have known his license was suspended the day that he was arrested. And then with respect to the reckless driving point, there's no allegation in the complaint, as the court observed, that he was perpendicular to traffic, that he was doing anything unsafe. The allegation was simply that he made a, quote, illegal turn, which is a legal conclusion, and that he caused an accident, which is also a legal conclusion, without evidentiary facts. And I want to briefly address how important it was for the complaint to be facially sufficient in this case. There was bail in Mr. Martinez-Fernandez's case. If he hadn't been able to pay it, he would have been at Rikers Island for 2 years, away from his family while this case was pending. As the amici talk about in these cases are a way for the state to raise money, often at the expense of poor people and of people of color who need to drive for work. Mr. Martinez-Fernandez was a taxi driver. He was one of those people, and this case had a really dramatic impact on the rest of his life. And so I wanted to make that clear. And if there are no other questions, thank you all.
Thank you.